Hello and welcome back to our YouTube channel. Well, it is lecture number 23 of Indian Polity today. And as you can see on the screen, the date is 8th July 2025. Well, as you know, we are delivering these lectures every day. And right now we have taken up Indian Polity. And in Indian Polity, we are discussing various schedules in Indian Constitution. So what are the various schedules? There are 12 schedules in Indian Constitution. In yesterday's class, I told you that we are going to discuss till 10th schedule today, and after that we will discuss union territories. About 11th and 12th schedule, we will discuss them and we will take up the panchayats and municipalities. So yesterday we left at the 8th schedule. We discussed a little bit about the 8th schedule. We discussed what does the 8th schedule contain. It contains languages. How many languages are mentioned in 8th schedule? We know the number. Earlier it used to be 14. Now we have 22 languages in the 8th schedule. And also we know that English, which is the official language right now of India with Hindi, it is not the part of the 8th schedule. Why? Because it is not an Indian language. In the 8th schedule, there are Indian languages are contained in it. So with respect to this, when we were discussing the languages, we understood one thing. Language in itself is very much emotional for the people. Language can be the reason for the breakdown of the countries. We can take the example of the Pakistan, how Pakistan broke in 1971 because of the reason. The major reason for that was the language, the instability in the country, how Bengali was not treated with the respect as they deserved, and because of that there was instability and it led to the breakdown of the country. So we very much understand it. We very much understand how much people are connected with the languages, how much people have the intimate relationship with the language. So language is to be preserved. It is the duty of the country to preserve every language in the country. So with respect to this, we have the 8th schedule under which we are, there are 22 languages. And also at the same time, we understood one thing about the official language of the country. Official language. What is the official language of the country? If we will talk with the constitution, what does the constitution say? Earlier constitution used to say that Hindi is the official language, but for 15 years English will also be there, and then after the 15 years different commissions will be created. They will discuss and they will end the English. But we saw that in 1963 there was agitation in the Madras. There was agitation in the southern states, and there was huge anti-Hindi agitation there. So because of that, the government was forced to make a law which created the scope for the official language for Hindi as well as English, and there was no time period for the English to be the official language. So English will remain official language until, let's suppose if tomorrow there is any amendment, then they will see. But here a question may come to your mind, sir, if the constitution says that there should be the Hindi should be the official language and English should end within 15 years, after 15 years, why this ordinary law was passed and it gave the scope for the Hindi, it gave the scope for the English? What was the reason for that? Why was it so? Why this this official languages act of 1963? Why by this act English was also given the official language status and indefinitely? The reason for that is because the constitution was very much clear. The constitution said, if the constitution gave the provisions to the parliament that you can make this law and it should not be deemed as the constitutional amendment. So it is what the constitution has already guaranteed to the parliament. So that's why there is no contradiction with this. It is not violating the constitution. So till now we understood that how many languages are there in 8th schedule. We understood the official language, it is Hindi and English now. And now there is another question: what should be the national language of the country? Or I can ask you a question: what is the national language of the country? What is the answer to this? The answer to this is no. There is none national language in our country. There is no national language in our country. The reason for that is, very much clear, because there is no a consensus between the different states. Before we will discuss on that, why Hindi is promoted by the state, why southern states are going against them, how it is being implemented through the various education policies. Before we will understand that, first we need to understand few important facts with respect to the official languages itself, with respect to the linguistic federalism, and how states communicate with each other, how states communicate, what is the how states communicate with the Supreme Court and High Court, how we can communicate with them, what does the what does the subordinate judiciary, which language they talk in. Let's first establish these facts, then we will discuss, then we will go to the main part where we will discuss how Hindi is being promoted. Is it the way the central government is trying to promote it? Is it the right way, or is it violating the constitution? We will discuss that. Here, let's try to answer few important facts which are very much important for your prelims preparation. So let me rub it first as usual, because I don't have any other screen. For that I have to develop the new one, and I don't think I will do so. So please wait here and let's answer this. First of all, for example, what is the official language of a state? What should be the official language of a state? What should be the official language of a state? Because we have, in our country, we have the federalism. Even it is at the linguistic level, we have the linguistic federalism. So if the states will have to choose the official language from the 8th schedule, then it will in a way violate the linguistic federalism. So here what is the case? The official language of the state can be any one. It can be from the 8th schedule, or it can be from the outside the 8th schedule. So it is up to the state itself whether what language they will choose as to be the official language. Now second question, in which language we can speak with the High Court or Supreme Court? For that it is very much clear, it is English. You would have seen that video where the High Court judge was scolding the lawyer that who was not able to speak in English. So it is very much clear that it should be English. And what about the states? What about the states, if they try to communicate with other states? For example, we have Punjab, and we have Tamil Nadu. Suppose they will try to communicate with each other. In which language they will communicate? It would be either Hindi, or it would be either English. So this could be the means of language in which they will communicate. But here you have to understand, there are many states in the North India who had who had achieved the consensus that they would speak in English. They will speak in Hindi whenever they will contact each other, whenever they will get connected with each other. So this is about the language spoken by the different states. The official language of a state, it may be from the 8th schedule, or it may be from outside the 8th schedule. Then we discussed what are the language, what is the medium of High Court and Supreme Court? It is English, 100% English. And what about this states speaking with each other? It can be Hindi, or it can be English. Now what about the subordinate courts? It can be any local language. Whatever the state chooses, it can be the any local languages. Now let's have a look. As we are continuing the 8th schedule, we are continuing the discussion on the languages. We understood the official language. We understood that how the subordinate judiciary can talk in local languages. Then there is another question. You would have heard about the classical languages. If you would have followed the current affairs in 2024, you would have known that, you would have understood that there are 5 languages were added into the classical languages. So that we have to understand. But before that, first let's try to understand what are the different special directives given in the Indian Constitution about the language. So let's try to understand that first. What are the special directives given under the Indian Constitution? You would have heard about Article 350. If not, then today you are hearing about it. Article 350. Article 350. Let's say you are residing in Tamil Nadu, or you are residing in any state. So you are residing in Tamil Nadu, and there is some grievance. You have some grievance. You want to file a complaint. So in which language you will file the complaint? This is what Article 50 talks about. In which language you will file a complaint? The language which you will choose would be is the language which is used in the center and the state. The language which is used at center and state. So you can file complaint in Hindi, you can file complaint in Tamil, you can file complaint in English. Can you file complaint in Telugu? No, it is not the language spoken in Tamil. So this is Article 50. Article 350, what does it say? For example, you have any grievance in any particular state and you want to file a complaint, then which language will you choose? It will be the language spoken at the center and the language spoken in that particular state. Then we have Article 350A. Article 350A, what does it talk about? It in a way gives the protection to the linguistic minorities. Protection to the linguistic minorities. So what is this about? For example, there are Marathi speaking people in the Tamil Nadu. There are Marathi speaking people in Tamil Nadu and they have kids. They want to get the education for those kids and they are not able to understand Tamil. So for them, what is this directive? It says that the Tamil Nadu government should assure that these children who are Marathi speaking, they will get the primary education in their mother tongue. This is what Article 350A says. Then we have Article 350B. What does the Article 350B say? Article 350B, it says that a special officer for linguistic minorities would be created. Special officer for linguistic minority, he will be created, and who will appoint him? He will be appointed by the president. And what would be his work? He will investigate if the rights of the minorities are violated, if the rights of the linguistic minorities are violated. So these are few directives which you need to know, which are very much relevant for your prelims preparation. Now there is a question may come to your mind, why it is now our focus would shift towards the mains perspective with respect to the 8th schedule. How Hindi is being promoted by the state, what are the cons to it, what does the constitution say about it, is they in line with the constitution or they are violating the constitution? Let's have a look at it, then we will deal with it. We will get the answer to it, and we should be, by getting this data from this video, you should be very much in a position that you can answer the question. Suppose you would have heard about what the government is trying to do. Present government, especially the BJP government, they have connection with Hindi. What they are trying to do? They are trying their best that Hindi, they are often trying best to that Hindi should be the national language. They are trying to promote it through various means. If you look at this name of the schemes, they are inspired by the Hindi words. So they are trying their best to make the Hindi as the national language. Second, what they are pursuing, that in the UN, the Hindi should be accepted. Hindi should be accepted as the official language. So they are trying that in UN Hindi should be accepted as an official language. Suppose if Hindi is, now what are the consequences to it? What are the other impacts of it associated with it? Suppose if they are trying their best that Hindi should be the official language of the UN, then what will they do? Once there would be any discussion from the Indian, from the Indian government, there would be PM will visit there. He will speak in Hindi. Then there would be the investment from the Indian government there, so that investment would be in this case that there would be the translation box there. The translators would be there who would translate the Hindi language in different other languages, in which the Indian government has to the Indian government has to pay for that, and they have to maintain all this stuff. The language would be translated to other languages. So in this way they are trying to do it. Now the question is it very much in line with the constitution or not? So for that we have to look at the Article 351. What does Article 351 say? Article 351 says it imposes the duty on the center to promote the Hindi language. So Article 351, they get this power. They are trying their best that Hindi should be the national language. They are trying their best that Hindi should be adopted as an official language in the UN too. For that they are ready to invest in millions. But Where from they get this power? They get this power from Article 351, which says that it is the duty on the state, on the center, to promote the Hindi language. So it is the duty on the state to promote the Hindi language, and how it can promote it in different ways. Now, what is the issue with the UN? There are criticism also. If you are going to promote in the UN, if you are going to promote Hindi as a UN, suppose tomorrow there is a PM, he is from Tamil Nadu. Then when he will go to UN, he will be forced to speak in Hindi. Then how it is a democratic in nature if you are forcing your PM to speak in Hindi? So there are various issues with it. Now let us see why they are choosing Hindi. What is the reason why Hindi is chosen? That it should be the connecting link in the country. Why Hindi is chosen? That it should be spoken everywhere. The reason for that is very much simple. About Hindi, if we look at the India's map, if we look at India's map, we know that the majority of the people in India, they speak Hindi. They understand Hindi. For example, if you want to communicate with a person from Jammu and Kashmir, he might not be aware of Hindi. He would have never read Hindi in his life. But and he is illiterate, and if you want to communicate with him, trust me, he would answer you in Hindi. If you would want to communicate with the person from the Punjab or any place, they will communicate with Hindi, because Hindi is very much understood and very much read, very much deep in these states. So Hindi is this language which is mostly spoken by the people in the country. And also, if we now let's have a look at the states in the South India. Now let's have a look at the states in the South India. Even in the South India, there might be people, in the South India. I had studied in Tamil Nadu. I know, there might be people who might not be aware of the English, if English is the national language, because they might be, they might be educated, but they had taken their education in what medium? In Tamil. Even if they are uneducated, they might not be aware of the English that much, but still they have this little understanding of the Hindi. So Hindi is in a way very known to the people of the country, So because of that, it can be the connecting link, and it can be easy for them to understand. So that is why Hindi is promoted. That is the reason why Hindi is promoted, that it should be the common language. Hindi is because it is spoken by many, and it can connect the people in a better way as compared to English. But there, with every argument, there is some, with every argument in favor, there is an argument which is against it. Now let's see what is the argument which is against the favoring Hindi. The argument against it is, why not we opt for English? Reason: English itself, it is not, in present times, English is not just a language, it has become a skill. India's record with respect to the BPO jobs, with respect to IITs, there are many multinational firms working in India, and the basic requirement for that is you should be the English speaker. So if you want to communicate with the world, we are in a better position to communicate with the world. If we will compare China with us, we are in a better position than Chinese to speak with the world, to communicate with the world, put our ideas in front of the world, than the Chinese people are able to do so. So it gives you the extra edge. And also, if we look at the literacy of the English, there are claims that in our country, look at Shashi Tharoor. I guess, not even the people from Britain can speak that good English as he is speaking. So English is very well versed in our country. So why not we opt for the English? Then there is third argument, which says that let's keep it here. Let's not discuss about it. Let it evolve by itself. Let it evolve naturally, and let the future generations to decide which language they should opt for. So this is the third argument. First argument, it is in favor of Hindi because it is widely spoken in India. It is the mother tongue of the most of the people in our country, and it is understood by everybody. If not fully, but partially, it is understood. Second, it connects the people all around the country. Third, it is majorly spoken by the people in our country and easy to understand. But then there are arguments in favor of English. English is not just a language; it is a skill now. You get jobs because of English speaking. There are we are living in the globalized world where we are connected with the whole every country. We are connected with everybody in this world. We have social media. We have all that stuff. to get connected with them, we need to speak English, and English should be made the national language. Then there is third, which says that, why not we stay silent, why not we shut up with respect to this, and let the people in the future decide what they want, let them evolve naturally, let them decide which language they would want to adopt. So this is the discussion about the Hindi being chosen as the national language. What are the arguments in favor, what are the arguments which are against it. Now let's move to the another topic. Now we discussed the official language of the country, we discussed the 8th schedule, what are the languages in it. We discussed the official language, we discussed the official language of the state, we discussed the local languages. Now there is another concept you would have heard, which I touched little bit when we started our discussion. We discussed about another thing, which is the classical language. So let's try to understand what this classical language is. What does the language get, how does the language get benefited if they if they get the status of the classical language, and what are the criteria for a language to get the status of the classical language. So let's try to understand that. Classical languages, to be a classical language, to be a classical, there is always, you would had watched movies, when there was internet was evolving, but still TV was there, TV was well respected, and you would watch movies on TV when there was only 3G or 2G. You would watch movies on TV. There was a separate channel for the classical cinema on DTH. I guess the channel number was 203 for that. So there were old classical movies, and if you would had watched those movies, you would had, even in the present time, you would like those movies, because they had those movies or those songs which were played in those movies, they had this connectivity, they have this connectivity that is still living in this present time. So that is the same cases with the classical language. First, it should be very much old. It should be very much old. How old? More than 18 to 2000 years old. Second, it should be original. It should be original. It should not be derived from the another language. For example, there are languages which are old, but they are derived from the other languages. So it should be original. It should be continuously spoken. Continuously spoken. It should be continuously spoken. So these are the criteria for the language to be the classical language. First, it should be old. How old? 15 to 2000 years old. It should have its own script. It should have its own script. So these are few criteria for a language to be added as the classical language. So earlier, how many classical languages there were? Originally, there were only 6 classical languages. Originally, there were 6 classical languages. What were these classical languages? It was Tamil, it was Telugu, it was Sanskrit, it was Kannada, it was Malayalam, and it was Odia. So these were the 6 classical languages earlier. But in 2024, few more classical languages were added. Marathi was added. Even though there is criticism with respect to Marathi that it is not that old, but still it was added, maybe because of the elections, whatever the reason was. Then Assamese was added. Criticism with Assamese too. Then Pali was added, which is not considered the original language. They did not have that old script, even though it emerged in the medieval period, during the Buddha era, during the Renaissance in the ancient history. It emerged there, it was spoken there, but still it is not considered that original. Then we have the Prakrit and Bengali. These languages were added as the classical language. Whatever the reason was, they were added eventually. This is the number. Right now we have 11 classical languages. 11 classical languages, and it could be very much relevant for your prelims preparation. A question about it can be asked in the exam. Now, why do they opt for this classical languages? What are the benefits for that? First of the most benefit is that the funds they get, it is huge, and it leads to what? It leads to the preservation of the language. If you are given the classical language status, then what will it lead to? Definitely it will lead to the job creation. How? There would be much research on the language. For that you will need more teachers. For that, if the researchers will increase, then it will further lead to the more teachers, and definitely more students will get involved, and eventually it would be spoken by many people, and there would be a lot of investments in it, and there would be courses in the universities on such language, and definitely the fundings they will achieve, that would be very much huge. So this is why it has been added as the why languages they try to go for the classical languages. Now the third important thing and the last important thing with respect to the 8th schedule is the recently the three language policy which the government has imposed, that there should be the, for example, there is North Indian state and there is South Indian state. In the ideally what should be the condition, it should be the English, it should be Hindi, and it should be some South Indian language. It should be spoken, it should be taught to the children there. And in the South it should be English, it should be the local language, local language, and it should be the Hindi. So this is how it should be taught in their particular states. But there are South Indian states who are very much in opposing this, and because of this there is huge tussle going on between the central government and the Tamil Nadu government. And there are there are funds which are restricted to the Tamil Nadu government, that we will discuss in the social issues. Right here, let's understand how government is trying to promote the languages, so that there should be the uniformity, there should be the mixing of the cultures, so that the people will know each other much better. And this is how it was they tried to introduce it, but still it was not a mandatory term for them. The North Indian states, what they did, they chose English, they chose Hindi and Sanskrit, and the Tamil, how Tamil is not accepting it. Other South Indian states, for them, how they will do it, English, their local language, and some other South Indian Dravidian language. So this is how they will do it. So there is not yet the consensus has not been achieved yet with respect to this, but still the government is trying their best to promote the languages. So this is about the 8th schedule. Now let's try to make it in a way, let's try to give the final understanding of this 8th schedule in few sentences. First, 8th schedule, it talks about the languages, and there are 22 languages in the 22 Indian languages in the 8th schedule. Is English part of it? No, English is not part of it. Then we understood the official languages. We discussed whatever the discussion was. Today we have two official languages, it is Hindi and it is English. Then we discussed what is the language spoken in the higher courts, High Court or the Supreme Court. It is definitely English. In the lower courts, it is about the local languages. Then after we discussed in which language do the states communicate with each other, it would be either in Hindi or in English. Then we discussed various articles, different directives, Article 350 A, 350, Article 350. We discussed Article 350A and Article 350B. Then we discussed Article 350, 351. What are the different directives given? How, for example, if you have to file a complaint, then in which language you should choose. Either the language should be from the center, should be spoken in center, or it should be spoken in state. Then we discussed the protection given to the linguistic minorities. We discussed that too. Under Article 350A, the protection given to linguistic minorities. Then we discussed about the special officer for linguistic minorities was created, and he is appointed by the president. Then after that we discussed why India is still trying, why center is still trying to promote the Hindi, where from it gets its powers. It gets its powers from Article 351, because Constitution imposes duty on the center to promote the Hindi language. And then we discussed why there is need for the promotion of Hindi language. There were various connections to it. We saw that Hindi is mostly understood in every part of our country. Majority of the people are very well versed with the Hindi. Even though they are uneducated, they will understand in Hindi and not in other languages. So that is the case. And with respect to English, we saw that how it is very much related to skill. It is not even just a language now. And now the people are evolving, they are getting more educated, and they are adopting to English. But still we cannot reach to that level that we will decide for the people. So it is better to let it for the coming generations, and they will decide on their own how they will evolve through the language. Then after that we discussed about the classical language, and that's what our discussion was about it. Now with this, the 8th schedule is over. Now let's move to the 9th schedule and try to complete it. Then we will have a great discussion over 10th schedule. After that we will discuss about union territories and complete our today's discussion. So let's have a look at the 9th schedule. This ninth schedule, it was not part of the original constitution. We know that it was introduced by the first Constitutional Amendment Act in 1951. And what was the reason for that? The reason for that, if any law, every law was, susceptible to judicial review, and if you want to evade that, if that is in violation of the constitution, and you still want to protect that law, you would add this that law in the ninth schedule. They will add that law in the ninth schedule, and the law will get protected. But there were various concerns with respect to that, and majorly when on 24th April 1973, 24th April 1973, the Supreme Court, through the Keshwananda Bharti judgment, gave us a basic structure term, a term called basic structure, and any law, it cannot violate the basic structure. So after that, still matter went to the court, and finally it was decided that with respect to the ninth schedule, if any law which is placed in the ninth schedule, it was placed before 24th April 1973, it is immune to the judicial review, and after 24th April 1973, if any law is there, it is not immune to the judicial review. Any law after 24th April 1973, it is not immune to judicial review, and still the law placed in the ninth schedule can still violate the constitution, but it should not violate what? It should not violate the basic structure. So this is what basically the ninth schedule is about. And in the ninth schedule, mostly agriculture based laws were put in that. Tomorrow, for example, there are many states, they want to exceed the reservation limit extra 50%, they will place that law in the ninth schedule. It should not violate the basic structure. So this is about the ninth schedule. Now let's move to the basic major discussion of today's class, which is the 10th schedule, or we can say anti-defection law. This is the major discussion of today's class. Maybe if it is that easy to understand, you can understand it in 5 minutes, and it may become that tough, it may take us 1 hour for that. So let's try to analyze the 10th schedule, which is anti-defection law. We discussed the procedure in Lok Sabha and Rajya Sabha. We saw that how MLAs and MPs are elected in Lok Sabha and legislative assemblies, and we saw that they are they can be disqualified. And what were the reasons for disqualification? Suppose they will lose the citizenship, they will be discharged, insolvent, mentally ill, and various other ways, maybe jail term for 2 years and more. So we understood what were the terms, and there we also discussed that there is another way in which they can get disqualified. And what is that disqualification? It is anti-defection law, and it is under the 10th schedule of the Indian Constitution. So let's try to understand what is this anti-defection law. What is this defection? First, let's try to understand what is this defection. What is this crossing of the floor? For example, there are political parties. Suppose there is political party A and there is political party B, A and B. There are 10 MLAs. There are 10 MLAs. Suppose few MLAs, 3 MLAs from political party B, will enter into political party A. This is called defection. What this is called, in simpler terms, it is called defection. Now, how ugly it can be, why there was a need for the anti-defection law, how ugly it can be, let's try to understand that. What are the reasons how dangerous this defection can be? Suppose there was an election in any particular state. There was an election, or at the center level. Let's make a hypothetical example. There was an election, and for the political party A, there were there are in a particular state, suppose there are 100 seats in a particular state. So who will win the election? Who will get the majority? And there are 2 political parties. Let's suppose there are 2 political parties. Who will win the election? Who will get the majority? Suppose political party A, they won 60 seats, let's suppose, and political party B, they won 40 seats. Now, ideally, who should make the government? It is definitely the political party A should make the government. Now, what will happen? The political body B, let's suppose, you know, they have the muscle power, they have the money power, they have these two important things, and they are desperately in need of the 10 MLAs in that particular state, or they are in desperate need of the 15 MLAs. Here we have political party A, which has the 60 MLAs, and what they cannot satisfy everybody because there is the limit of how many ministers you could have. There is the limit of 15% of the total strength, so they cannot exceed the limit. Now what will happen? There would be MLAs who will not be satisfied with political party A. What they will do? Political party will approach them, B will approach them, and they will tell them that if you will join us with 15 members, and we will make you the CMs, we will give you the top ministries, and you will enjoy the ministries for 5 years. So eventually what will happen? The 15 members from the political party A, they will join political party B. And now political party B has the 55 members, and the political party A has only 45 members. Now change of the government. Understood? Now again, let's suppose if there was no defection. Now the political party A will approach the members in the political party B, and they will do the same. So it will be the continuous process, and what it will lead to eventually, it will lead to the stability. It will harm the stability of the politics. It will harm the political stability. It will create the political instability in the state. There would be the political instability in the state. So this is one of the reason, this political instability in the state, this is one of the reason that there was the need for the anti-defection law. And about anti-defection law, please understand that it was not originally part of the constitution, but was introduced through the 52nd Constitution Amendment Act in 1985. It was introduced through the 56th Constitution Amendment Act in 1985. So this you had understood. Now there was, because of this, it could lead to the political instability. People vote for them so that they will govern them, they will provide them the benefits, they will bring up the schemes, they will bring up the policies, and if there is political instability, it would in a way violate the rights of the people. Definitely it is not good. The second reason which is highlighted, that it will lead to the mass corruption. What it will lead to? It will lead to the mass corruption. If there was no defection, what it will lead to? It will lead to the mass corruption. There would be the huge corruption in this. You would promise something to the MLAs, you would promise a lot of money to them, and you will give this lot of money, and eventually it will impact the economy of the country. And then third, it is the violation of people's trust. Suppose in present time, if I personally believe, I may be wrong here, that if the BJP government is winning the elections, it is because of few members in the BJP government, and especially it is because of the Narendra Modi Sahab. It is because of the Mota Bhai Amit Shah, Home Minister. Mostly because of these members in the BJP, they are winning the elections. If anybody is contesting for the BJP, people are not voting that particular person. They are indirectly voting whom? They are indirectly voting this political party. They are indirectly voting for them. They are indirectly voting for the BJP. They are voting for the ideology of the BJP. So if a person is elected on this basis and tomorrow he switches the sides, it would lead to the violation of people's trust. They will believe that we gave him the votes, but still, we gave him the votes, we subscribed our votes to him because we believed that he will have the same ideology as of the BJP. But today what he did, he deflected. So it will definitely lead to the violation of the people's trust. So definitely, to curb all this, there was the need for the anti-defection law, and it was brought in through the 52nd Constitutional Amendment Act. Now let's see what can be the reasons how you can be disqualified under the anti-defection law. Here we understood what was the reason why it was brought in. Now let's try to understand what can be the reasons how you can lose your seat, you can be defected under anti-defection law. Let's try to understand that. Let's try to understand that in a simpler terms. As I told you, this is very easy to understand, but if you want to complicate it, it will get very much complicated. First, the first major reason, you are aligned to any political party. Suppose I contested for the BJP and tomorrow I voluntarily, resigned from the political party. So I will be defected. Now, here a question may come to your mind: what if the BJP government, they eliminate me? What will happen to me? For that the Supreme Court is there. They had given the judgments. For that I would act as an independent member. Still, if the BJP will eliminate me, I will be part of the Lok Sabha, but I cannot join other political party. And what about the whip of the BJP? That will not be binding on me. So about the resignation, voluntary resignation, I would be disqualified. If the government, if the, for example, political party will, eliminate, will exit me or eliminate me, what will happen to me? Will I be disqualified? No, I will not be disqualified. But still, there are few important conditions which are put forward to me by the Supreme Court. What are those conditions? That I cannot join other political party. I am the member of the political party, but the whip of the BJP is not binding on me. So this is the first one. Then the second, vote against the 3-line whip. When we discussed the parliamentary procedure, we discussed 1-line whip, we discussed 2-line whip, and we saw that if you violate 1-line whip or 2-line whip, nothing will happen to you. But if you violate 3-line whip, then you will be qualified for the disqualification. So this is how you get qualified for the disqualification. You can be disqualified, but still there are certain certain safeguards given under this. If within 15 days the political party will decide not to react on it, then not if the political party decides to accept your defection, then you will not be disqualified. Otherwise, you will be disqualified. So within 15 days, this is if you will vote against the 3-line whip. Then the third, this is for the elected members. This is for those members who belong to the political party. Now the third point which you need to know is, for example, I got elected, I first approached BJP government. They did not give me the party ticket. Then I approached Congress. They did not give me the party ticket. Now I have to contest the election, and I independently contested the election. After contesting the election, I am the independent member. I am the MLA in the Lok Sabha. Now MP in the Lok Sabha. Now what will happen to me? If after election I join any political party, I will be disqualified. So it will lead to the disqualification. If after election I will join if I am an independent member, and after election I join any political party, I will be disqualified. This is third. Then the fourth, it is about the nominated member. We know there are few nominated members in the Rajya Sabha. What will happen to them if they are the nominated members, and after 6 months of the nomination, they join with any political party. After 6 months of the nomination they join, then they will be disqualified. If within 6 months they join, they will not be disqualified. So these are some important points with respect to what are the ways in which you can get disqualified. And who will decide over the disqualification? It is the speaker who will decide over disqualification. Is there any time limit for the speaker to decide over the disqualification? Now let's discuss over it. Then we will see what are the limitations to the anti-defection law and what were the earlier limitations. And we will discuss about the speaker here. Is there any limitation to the speaker? What does the court say about it? Suppose if there is a disqualification case in Rajya Sabha, then it would be the chairperson who will decide over it. If not chairperson, then deputy chairperson. And if it is in Lok Sabha, it would be the speaker or deputy speaker. And if it is in legislative assembly, it would be the speaker. If it is in legislative council, it would be the chairperson there. So these are the members for whom with respect to the assembly is there, they have the authority. Now the question is, if we look at the Lok Sabha and legislative assemblies here, let's focus on them. The speaker who is going to decide over the defection, the speaker is aligned to the political party, he got contested from. Eventually speaker is from the house itself. Speaker is from the house, so he is aligned to the political party. He got elected to this house through a political party, so he is a speaker, and by convention we follow that he would be from the governing political party. So there are always chances that he would be biased in his decision, and we have various cases with respect to in various states where it was favoring the governing political party, his political party. There he stayed silent on this matter, and in other states what he did, he acted very quickly. Or we can say with respect to Rajya Sabha recently, with respect to the Nitish government, what happened there? When the when the JDM, they got aligned, they ditched the India bloc, and they joined with they joined with the BJP bloc. So there were few MPs in the Rajya Sabha, who who were forced to be disqualified, even though they had not given the resignation, but they were forced to disqualify because they were very much against this decision of the Nitish Kumar, and that is different, which we will discuss there. So the point of taking the discussion about the speaker right now is that the speaker is always from the political party, and there are chances that he will favor some political party. If the decision is if he has to take the decision and it will favor his political party, then he will take the decision quickly, and if it is against the political party, he will take the decision against the political party. So there are always chances of the biasness from these officials. Now with respect to this, various cases went to the Supreme Court. Sir, there is a case pending with respect to the disqualification. For example, with respect to the there was a case with respect to the Telangana government. There was a case with respect to the MP from the Karnataka. There was a case with respect to the various others. What Supreme Court said? Supreme Court, what earlier court used to say? Court used to say that, we are bound by our decision. Once the speaker will give the decision, then it will go for the judicial review. Right now, we are bound by it. We cannot decide over it. Yet we had not discussed whether the speaker's decision is open for the judicial review. Let's get the answer to that. It is open for the judicial review, and till recently it was judiciary was bound. Till the speaker will not decide over it, judiciary was very much bound to decide over it. So they did not have the position to answer over it. But in the Manipur case, where MNAs joined BJP from Congress, and then the matter went to the Supreme Court, and finally Supreme Court's two-judge bench of the Supreme Court, they invoked Article 142, and they ordered the speaker. What they ordered speaker? First to cancel first they cancelled the ministry of that particular person who was given T. Shan Kumar, I guess was his name. His ministry was cancelled because he had done the defection. And second, they imposed the time limit on the speaker that it should be achieved through within 3 months. The speaker should decide over over the disqualification of any particular person. It should not be unlimited time. And also the Supreme Court here suggested that it is time for the Parliament to decide whether such decisions with respect to disqualification, it should be taken by the speaker, or it should be taken by some independent authority, or it should be taken by the president or the governor. So here it is about this was the discussion about the disqualification by the speaker, as speaker is the very much member of the he belongs to the political party. Even though he will once he will be given the post of the speaker, he may vacate his seat from that political party, but still he will be bound by that. And also one thing important about defection which you have to understand, which is very much critical. Defection, what is this defection? what you what is this? What do you defect with? You defect with the political party. It is not defecting with the house. So here is a thing. This defection, it is or we can say resigning from, it is resigning from the political party, not resigning from the house. You can resign from the house, that is different, that won't be counted as a defection, but resigning from the political party would be counted as a defection. So these were important points which I wanted to highlight here. Now we understood that what can be the reasons for the defection. For example, if you voluntarily resign, you vote against or abstain from voting when there is a 3-line whip, even though you won't vote, that is also, you will also be liable for the defection. Then third, you are the independent member and you join other political party after election, then you are disqualified. Then you are a nominated member and after 6 months you join any political party, you will be disqualified. And we saw who will disqualify. It would be speaker or chairperson in the Lok Sabha and Legislative Assembly. It would be speaker and chairman in the Legislative Council and the Rajya Sabha. But originally, there was an exception given to the disqualification. What was the exception? First exception was that if 1/3 of the members, if 1/3 legislative members of the Legislative Assembly defect from the political party, they would not be disqualified. So for example, if any Legislative Assembly, it has the maximum number of 100, suppose, and out of this 33, or we can say 34, make a round off it to the 34 members, which is 1/3 of the 100, they defect from the political party and join another political party. Originally it was deemed that it is not a defection, it would not lead to the defection. But when it was studied properly, what it led to? It led to the mass defection. It led to the mass corruption, and it led to the mass breakage of trust of the people. So eventually in 2003, by the 91st Constitutional Amendment Act, this exception was removed under the 10th schedule. This exception, even 1/3 or 2/3 members of the political party would defect, it would be removed. But here, there is another exception. What is that exception? That exception is of the merger. That exception is of the merger of a political party. Here you may raise a question that, sir, you told that 2/3 members of the political party, if they will split, they will be liable for the defection. But in the merger, the thing is very much different, is very much contradictory to your statement, and that we will understand here. What we understood in the split? In the split, whether it would be 1/3 or 2/3 members of the political party, they will split from the political party and join other political party, it will lead to the disqualification. What is the merger? Merger is, suppose there is a political party A and political party B. Suppose they decide to merge together. Political parties are merging together, not the MPs. It is the political parties which are merging together. And this merger should be supported by 2/3 members of the political party. If it is supported by 2/3 members of the political parties, then of the political party A, then what will happen? This merger, they are making these two political parties are becoming the one political party, which is B. Suppose it would be B, which is the bigger political party. Now this merger is not liable for defection, but this is the most misused, this is the most misused term or misused thing which is being applied in the constitution, which is being applied in the legislative assemblies. What they do, 2/3 members, they will decide that it is not the political party and they will merge with another political party. So they will say that we are the original political party and they will merge it, even though it is a defection, but they are not liable to defection because it is most misused term. And eventually it is the speaker whose political party will get satisfied, he will favor them. We saw that also. So in case of merger, we discussed what would be the this is also one of the exception to the defection. And then there is another exception to the defection. What is that exception? For example, there is a speaker, and there is the deputy speaker, and there is the deputy chairman. Why not chairman? Because he is not the member of the house, he is the vice president. And when they are elected on these posts, what they do, they leave their political parties, they resign from the political parties. So why they do this, they resign their political parties? Because so they want to be seen as the partial entities, because they are holding these offices. For them, they will not, it will not lead to the defection of these people. But if they leave the political party and join another political party, then this will lead to the defection of these people. So this is also one of the way you can, one of the exception in this. And also we discussed who will take the decision. It is the speaker, who will take the decision. And what if the speaker is under defection, then decision may be taken by any member of the house. Then we discussed about the chairman. He cannot be disqualified because he is not the member of the house. Now let's see how, this is what the laws state, this is what the law says. But we know that, where the law ends, the diplomacy starts, the politics starts there, the dirty politics of the politicians start there. They will always try to find out the loopholes within these laws. Now what were the different loopholes they had tried to find out within these laws? Suppose there is a political party, there is a legislative assembly, and there is legislative assembly A, there is legislative assembly B. Suppose these are two legislative assemblies. Earlier what used to be? Earlier, and for this legislative assembly, a majority is 100 MLAs. A has got 55, B has got 45. So for B to get this, to come into the power, what they can do? What was the loophole here? What they could have done? First, the 10 members from the A would come to this party, or maximum 6 members would come to this political party, but it would lead to the defection. What they will do, they will leave the political party here and they will do the defection. Now another option available to them is, what they will do, they will resign from the house. These 6 members will resign from the house. When these 6 members will resign from the house, now how many members does A have? They have only 49. And how many, suppose they have only, no, let's suppose not 6 members, let's suppose 11 members from A. What they will do, political party B will approach 11 members from the A and tell them, resign from the house. You want to get away from this, you want to get away from this political party, you want to get away from it, from this issue. What you should do, you go and resign from the from the house, not from the political party. So they will resign from the political party. Now what would be the status of these political parties? Once they will resign from the political parties, they will resign from the house, and after resigning, what they will do, they will join, they will resign from the house, and then they will join, and there would be vacancy in these constituencies where from they were elected. And now what they will do, they will join the political party B. Once they join the political party B, is it liable for the defection? Karnataka, this happened in the Karnataka. The Karnataka High Court earlier said that it can lead to the defection, but it went to the Supreme Court. The Supreme Court said no, it cannot lead to the defection, because it is eventually the people who are going to elect them. So once they joined the political party B, now what will happen at these 11 constituencies? There would be the re-election. What will happen? Re-election. And when there was re-election, then it will decide whether they will win or they will lose there. It will decide whether they are going to win there or they will lose there. So in this way, this is one of the loophole which can be violated by the political parties in this in this scenario. So this is one of the loophole which can be violated. Now, this is how it is being misused. This is one of the loophole with respect to that. And other loophole was they the political parties would have tried that they will give them the ministerial positions. First, they will resign and they will defect. Then they will give them the ministerial positions, and within 6 months they will get elected again. They will contest the election, but it was through the 91st Constitutional Amendment Act 2003. It was very much removed there. It was very much highlighted that the defector cannot be appointed as a minister, and he cannot take the remunerative political post. And these two important points were very much added there. Now, the another question may come to your mind: who can complaint who can give the complaint about the defection? Who can approach the speaker that, sir, please, or the chairperson, sir, please defect the particular person, disqualify the particular person because he has done the defection. Earlier it was believed that it is only the legislatures who has the locus standi. Earlier what was believed that it is only the legislatures who has the locus standi, that only they can claim it. But later the matter went to the Supreme Court, and Supreme Court said any voter do so. So any voter has locus standi, they can go to the speaker and approach him and ask him to go for the you know defection. Then we also discussed, if you voluntarily resign, you submit your resignation letter, then you get disqualified. What if the resignation letter is not submitted, but it will be presumed that if your actions are against the political party? For example, we took the case of the JDU, where Anwar Ali and Sharad Yadav, they were criticizing the Nitish Kumar for polting, for changing his alliance towards the BJP government, BJP. So for them, they were criticizing this move of the Nitish Kumar. So for him, what Nitish Kumar did, he approached the Rajya Sabha chairman and told him to disqualify him. Rajya Sabha disqualified him, and it was presumed that it is in violation of what? It is very much it is very much clear, even though they had not given their resignation, but still it is believed that they had resigned because their approach is very much different from their actions. So this is about the disqualification. Let me see if there is any other important point which is to be discussed. We discussed about the speaker's partiality, in certain cases, how it is favoring political party, in certain cases. And we also discussed that if any person is for example, there is a person who is who is expelled from the political party, what will happen to him? He will still be the member of the legislative assembly, but VP is not binding on him, and at the same time he will be the unattached member, but at the same time he cannot join any other political party. We discussed that. Then we also saw that how it is how it is liable to the judicial review, that judiciary will decide. But we saw that how earlier the speaker used to take lots of time in deciding that, and eventually in the Manipur case, it was finally decided that it has to decide. Judiciary has to decide it within 3 months. The speaker has to decide it within 3 months, and it requested the parliament to rethink and discuss about it, whether it is the proper time that we should decide whether this quasi-judicial authority of the speaker, it should be shifted to other authorities like president or the governor. So this is also the important thing which we had achieved. Then the last thing about the defection, which I guess is important for you to understand, it is the Nabam Arabia case 2016. Nabam Arabia case 2016. Let's see what is about it. What does this say? For example, I'm an MP of a particular political party. I belong to the BJP. I contested for the BJP and I got elected for the BJP. Now I want to, defect. But I know if I will defect the speaker, what speaker will do? The speaker will defect me. So what I will do? I will, introduce a motion on And I will, so for to evade this, what I will do, I will introduce the motion to call for removal of the speaker. I will introduce the motion to call for removal of the speaker. So what I will do, I will introduce the motion to call for the removal of the speaker, and the speaker, once I will introduce this motion, then the speaker cannot decide on anti-defection law. Then the speaker cannot decide on anti-defection law. So in a way I can evade the defection. But eventually the matter went to the Supreme Court in the Shiv Sena case, in which Supreme Court said that we shall revisit the Nabam Rabia case, and 7 judge bench is going to review it. So eventually they will decide whether it will continue or not. So this is about the 10th schedule. I hope you had understood the anti-defection law. What are the, why it is necessary? Because it is necessary because there should be the political stability. Otherwise there would be Ayaram Gayaram. He was the Gayaram person, MP from the Haryana. He used to shift his political parties. In 15 days he shifted 3 times. So because of him there is this term Ayaram Gayaram, and because of him it led to this, because of Haryana it led to the anti-defection law. And through the 52nd Constitutional Amendment Act in 1985 it was brought in, and there were the terms mentioned, what can be the reasons for the defection, we discussed that, and what can be the exceptions in it, we discussed that. Then we discussed how speaker can manipulate it, and eventually in the Manipur judgment how the Supreme Court set the bar that it should be decided within 3 months, and it should also be decided that it is the option for the parliament to think over it, whether this quasi-judicial authority should be kept with the speaker. That we understood. Then we also saw that how there can be a loophole in it. For example, suppose the political party will ask 15 members to resign from the political party, from the house, not from the political party. Once they will resign, then they will join other political party, because they are not hosting the MPs. They will join another political party, and there they will contest for the election, and in that way they can win the election or lose the election. And it was made very much clear that it is in line with the constitution, and it is not, it is something in line with the democracy, concept of democracy. So with this, in nutshell, the 10th schedule is over. Now let's move to the last topic of today's discussion, which is the union territories. We discussed the federal structure of the country. We discussed that how powers are shared between the center and the state. We have at the central level we have center, we have state. We have federal structure in our country because we have double government. We have the division of powers, so it makes it a federal state. And we saw that the powers, what state can make laws on, what list we have, state list and the concurrent list. Then we have the center on what things it can make laws on, union list and the concurrent list. And the residuary powers, they are kept with the center. We discussed all that, but at the same time, we have union territories too. We have union territories too, but these union territories are very much unique. They are not similar like states. They are very much similar. Their governance is very much similar. But the union territories, their governance is different in different UTs. For example, if we look at the Puducherry and Delhi, they have the legislative assemblies. But if we look at other Chandigarh, Lakshadweep, if we look at Ladakh, if we look at Daman and Diu and Nagar Haveli, and and what is left, which Puducherry, which one is left, and Daman and Diu and Dadra and Nagar Haveli, Andaman and Nicobar, their political structure is different. So it is very much important for us to understand the union territories and see how they are governed, how the laws are made there, and let's try to understand few important facts with respect to the UTs which we need to know. First of all, let's try to understand why do we need the UTs. Here I would highlight just one point which is, I guess, important for you. First, the political and administrative stability. For the political and administrative stability, there is the need for the UTs. For example, we have Chandigarh. When when Haryana was carved from the Punjab, there was the question over the Chandigarh, whether it should be the part of the Punjab and Chandigarh. Then it was decided that for the 10 or 15 years, I guess, 15 years it will remain the UT, and still it is continuing to be a UT. And then there could be the political and administrative consideration. There are some say that there are cultural considerations too. Cultural consideration, for example, you have the unique culture Puducherry, we have the Dadra and Nagar Haveli and Daman and Diu. Then some say it can be because of the strategic implications, for example Andaman and Nicobar, Lakshadweep and Jammu and Kashmir and Ladakh. So there can be different reasons for which the union territories are created. So till now right now we have 8 UTs. How many UTs we have? 8. What are these 8 UTs? We have Ladakh, Lakshadweep, Andaman and Nicobar, Chandigarh, Daman and Diu, and Dadra and Nagar Haveli. Then we have Delhi, we have Puducherry, and we have Jammu and Kashmir. So let's try to understand few important facts about the UTs. Few important facts about the UTs. Important facts about UTs. First, there is no uniformity in the administrative structure. No uniformity in the administrative structure. There is no uniformity in the administrative structure. President Article 239 says, Article 239, that President shall administer a UT through his officer who is that Article 259 says the President shall administer a UT through his officer, directly, either directly or through his officer. This officer can be administrator, it can be lieutenant governor, it can be the chief commissioner, it can be anyone. So Article 339 says that the President shall administer the UT. Then we have different UTs. We have 5 UTs. For example, we have Ladakh, we have Lakshadweep, we have Andaman and Nicobar, we have Chandigarh, we have Daman and Diu, Dadra and Nagar Haveli. We have these, in which they are, in which there is no legislative structure. Parliament will make laws for them directly. Parliament makes laws for them. Then we have other, other set of UTs. For example, Puducherry we have Delhi, we have the Jammu and Kashmir. For Puducherry, under which law it is governed? Under Article 339A. For Delhi, it is under Article 239AA. For J&K, it would be same as Article 339A. So there is difference. For Delhi, you will have a legislative assembly, but still there is difference. Law and order, police and land is not under your control. So there is difference. And still, even though they have the legislative assemblies, can center make laws on any matter of the state list? 100% they can make laws on any matter of the state list. So what are the items they can make laws on? With the UTs with legislative assemblies, what are the items they can make laws on? They can make laws on the state list, they can make laws on the concurrent list. But can center make laws on the state list? 100% they can make laws on the state list, because it is eventually under the control of the center. Parliament can still make laws for these UTs. Now, what about the judicial structure in these particular UTs? For the judiciary, we only have 2 UTs who have the high courts. For example, for Delhi and Jammu and Kashmir, they have their own high courts, and for the rest of the UTs, they don't have their own high court. They come under the high court of the nearby state. So please understand that there are only 2 UTs who have their own high court. It is Delhi and it is J&K. Others, they don't have their own high court. they come under the jurisdiction of other high courts. And also all the UTs have their subordinate courts. All the UTs have their subordinate courts. So please do remember that. Then let's move to the another issue. Now let's discuss the UTs. First we will discuss the UT of Delhi. Let's try to understand a few important features of the UT of Delhi. Then we will move forward. About UT of Delhi, till 1956, it was a state. After 1956 Reorganization Act, it lost its statehood and it was converted into a UT. What was the need for that? Because it is the capital of the country. There are various assets of the center. There are foreign embassies. There are various many countries want to bring in their embassies. There are various authorities there. So it was definitely the need of the time that it should be governed by the center. If it would have been state, then there would have been the huge conflict of the interests between the two. So eventually, to get away from this conflict, it was made a UT. Till 1992 and 93, there was no concern over this. Then in the 1992-93, this was given some, the UT of Delhi, it was given some representation. It was UT, till after from 1956 till 1992-93, it was just UT. It did not have the legislative assembly. But after 1992-93, it had the legislative assembly. It was given representation. It will have the chief minister, council of ministers, and other members. And because it has the huge population, Delhi has the huge population, so there was a time had come that they should elect they should govern themselves by their own. So for that, Article 239 was amended and Article 239A was introduced. And what does Article 339A say? It says who will appoint them. It is who will appoint the council of minister and chief minister. It will be the president through his agent. Through his agent his administrator would be the lieutenant governor. And also it was very much highlighted that with respect to this appointment, they will have power, the legislative assembly, they will have power to make laws with respect to everything in the central, in the union list, and in the state list and the concurrent list, except law and order, except police, and except land. Except these things, they can make laws on any aspect. Why these things? Because these were very much important. It would had again caused the friction between the two. Till 2013, there was no conflict between the two. But after 2013, when the government changed and the Arvind Kejriwal came up with the government, so he became the CM. And he became the CM, and the real problem started. What he did? He tried to pass the bills. But they were rejected. They were held by LG. They were not passed further by LG. And for him, till this date, it was believed that it is for the union territory, they can only recommend to the LG, and this recommendation is not binding on the LG. So the matter went to the court. And when the matter went to the court, matter went to the court, and under the case, government of NCT of Delhi versus Union of India. Union of India, it was heard by the 5-judge bench, and it decided that CM is the executive head and lieutenant governor. Under this judgment, it was decided that CM is the executive head and lieutenant governor is bound by the advice of the CM. Then further, what happened? BJP government, the central government, they were not satisfied with it, so they decided, let's still do whatever we want to do. And they said that the services, it would remain under the center. For example, you want to appoint, for example, there are various posts, various services. Let's suppose they will be under the center, under the and they would be under the UT, under the government of the Delhi. But what about the posts there? Who will appoint the posts? For example, IAS officers, who will appoint them? So it was thought that it would be they would be appointed by whom? They would be appointed by the center. Then the matter again went to the court in 2023, and the court said, the Supreme Court said that the government, you know what Supreme Court said, that these services, they are services are with the with the legislative assembly, with the government of the Delhi, not with the LG. So services, on the matters of the services, it is the government of the Delhi which will decide over it, except three items, which was public order, law and order, police and law and order, police and public order, law and order, land and police, sorry, law and order, land and police. Except these three, if any services is extra these three, that would be decided by the Delhi government, by the legislative assembly, who is being elected there, elected government. When after that, the central, being central, they brought up the law in 2023, and the law, they brought up the act, and the act is the Government of National Capital Territory of Delhi Amendment Act 2023. Under this, the government passed this law, that the government, first they said the government of Lieutenant Governor, and the second thing which they mentioned, that the services are under center. So this case again went to the Supreme Court, but this time Supreme Court did not decide it over it. It is still in the Supreme Court, and let's see what will happen to this. So this is in a nutshell about the Union Territory of Delhi. Earlier it used to be the state. From 1955 it became the UT, and in 1992 and 93 it got the special status, where it got the representation through the Article 239 AA. Under that, it was three items were excluded for them. It was law and order, it was police, and it was land. But then things went clear. In 2013, the mismatch happened between the political party at the center and the state level, at the at Delhi, at the Delhi government. So mismatch started, and the case went to the Supreme Court. Earlier, the Lieutenant Governor would not pass any bill, and then the Supreme Court made it clear that it is the executive head of the Delhi would be the elected government. So Lieutenant Governor is bound by their advice. Then further matter went further with respect to the services. Then the Supreme Court again intervened that the services are with the Delhi government, elected government, rather than the center, and accept the three items which we know. And further, at the end, the government brought up the Amendment Act, the Government of National Capital Territory of Delhi Amendment Act 2023, in which they brought up few changes. For example, first they brought government of LG, and then the services are under center. So the case again went to the Supreme Court, but this time Supreme Court did not decide it over the case. It is still pending in the Supreme Court. So in this way, we completed our today's discussion. I hope you would have liked the video. I hope you would share it with your friends, and I definitely hope you would subscribe the channel. Thank you for staying with me. Thank you very much, and have a nice day.